is, I guess, was posed as the first and only responders, but there was also the Huron Township Police Department, and I believe they were the first responders. And there's no body cam video from that particular department. So my issue with that is that's going to be a huge grading issue because that can prove my guilt, for instance.
All right, so let's take one issue at a time. Number one is you don't think the complaint is adequate,
No,
correct? All right, I'm just confirming your argument so I can give Mr. Greco's response. Let's respond about the complaint.
Well, the complaint is compliant with the court rules and the statute. What he's talking about is the body of the complaint restates the statute, but the form is the court-approved form. And pursuant to the statute and the form, if you look at the complaint, it provides for the nature of the offense, which he admits is there. The time using the official state form is put in there, the date and time, and the location. So it provides, we're a notice pleading state, Your Honor. Provides the crime, it provides the nature of the offense, provides the location, and it provides the date and time. It's all there in the form. Yes, that says the statute, but if you look at the entire form, it has name, location, date, charge, and the complaining witnesses, which we then supplemented as far as witnesses with respect to our witness list that we filed.
All right, anything else on that topic, Mr. Stokes?
All right, guys, buckle up, because right out of the gate, this defendant comes in swinging. He's challenging the very foundation of the case, arguing the complaint itself is unconstitutional and claiming police misrepresentation and missing body cam footage. The judge, however, stays calm and methodical, letting the prosecutor explain that this is a standard, court-approved complaint used for decades. The tension spikes when the judge flatly denies a motion and reminds him that appeals exist, setting the tone for a courtroom where patience is already wearing thin.
I think the law as well as the Constitution is clear on how this should be, drawn up. And in the body of this complaint, this is unconstitutional. There's case law against it. Don't know why the prosecutor is acting police oblivious to that.
Okay, so he's not the only one, because I've only been in this business 40 years, and that's the kind of complaint I've always seen. So I'm denying your motion on those grounds. You are free to appeal me to the circuit court. Now, your next item is, what about discovery? What are you saying? You think you should have had some video from Huron Township Police?
Yes.
And because you don't have that, then what relief are you requesting?
Well, like I said, the Romney police.
No. Don't just restate your argument. I said, what relief are you requesting? I understand your argument is that you're missing some discovery.
This body can't put it on the rebound.
Okay,
Respond.
please.
Sure. First of all, the police report is a summary by the Romulus Police Department about what happened. We try to be as detailed as possible. Some things may or may not be omitted, but this is why police reports are police reports, and witnesses and testimony and all that is there. So there is no dispute that because of where the location of this accident occurred, that Huron Township was the first responder. They get there, that's the way it was dispatched by 911. When they get there, they realize, well, this vehicle probably was close to 11 o'clock at night, so the Huron Township police officers were probably happy to say, oh, wait a second, this happened in Romulus. So they contacted Romulus, we go out there to then take over the investigation. When the Romulus police get out there, which was on the video and everything that was produced to the defendant, both to him directly via email and to his counsel, it shows us showing up, other officers from Huron Township are there, and Mr. Stokes was already in the ambulance. Okay, so there's no issue with respect to what's in or out of the police report. That's all going to come out in testimony today.
Okay.
Now, what he's asking for is, which is for the first time that I'm hearing it.
Now, this is where things get uncomfortable. The judge zeroes in and demands one simple thing. What relief are you actually asking for? Instead of a clear answer, the defendant circles back into argument mode. You can feel the frustration building as the judge shuts it down, making it clear that repeating complaints isn't the same as making a legal request. This brief exchange exposes a major weakness in the defense and shifts momentum firmly toward the bench.
Is any video from the Huron Township? That's not my discovery. I don't have it. I've never had it. If you request it from me, I have to request it from someone else. I have subpoenaed it. My own witnesses in this case, I've subpoenaed it. It was Mr. Stokes wanted stuff from Huron Township. You should have gone to Huron Township and subpoenaed it or done a Freedom of Information Act request. I don't have it to produce.
Okay. Mr. Stokes, anything else as to the Huron Township videos?
Yes, I just want to say for the record that, he said that I should have, requested it myself, first of all, at the time. I was still, being represented, so it might have been a good idea for my defense attorney to do that at the time. Second, if he had knowledge of the fact that, the Huron Valley Township Police Department was involved,
Huron Township Police Department.
if they were involved, then as a prosecutor, that's his job to do that. That's part of the case.
No, that's not his job. His job's not to get all the facts that could possibly be of interest to anyone. His job is to put his case together. And we're over a year into this case now. You've had 4 or 5 MIDC attorneys, and this is the first time anybody's made any request about something from Huron Township. And we're not going to stop today's proceedings so you can do some kind of request to Huron Township.
Here, the prosecutor takes full control of the narrative. Step by step, he explains how the first responders arrived, why jurisdiction shifted, and how the investigation was properly handled. Most importantly, he dismantles the discovery argument by making it clear that prosecutors are not required to hunt down evidence from other agencies for defense. The judge reinforces this point, noting how long the case has been pending, and firmly refuses to delay the trial.
So do you have anything else before we call the jury in and get started?
Reserving the record that,
We're making a record. This is all on record.
it's, that's contrary to Brady.
Okay, then you can appeal that decision as well. Every one of my decisions are appealable. All right. Anything else before I get the jury in?
I think that's all.
Okay. How are we doing on numbers, you know?
Members, the count, we get count. Thank you.
This final stretch seals it. The defendant insists on making a record, hinting at unfairness, but the judge responds with quiet authority, reminding him that every ruling can be appealed. With no more legal ground to cover, the court smoothly transitions into trial mode, discussing jurors, tablets, and logistics. It's a clear signal that arguments are over and consequences are next. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.
15, sir. And that's flowing in.
15. We'll wait till 9:05. We'll get started at 9:05. Mr. Stokes, everything we do is on a tablet. So there will be a tablet available for you if you want to follow along with everything. The jury, once the jury is picked, the jury will have a tablet so they can follow along with jury instructions and so forth and so on. Should be right there. If you need some help walking through it, let us know and we'll tell you how to find what you're looking for. You can ignore it. You don't have to use it at all. I'm just letting you know it's available if you want to use the same resource we're going to give to the jurors once they're picked.